Welcome. The study of equity is fundamentally an inquiry into the ethical soul of the English legal tradition and its global progeny. To understand it, we must understand the architecture of our legal history. Unlike the common law, which historically prided itself on the rigidity of the writ system and the certainty of precedent, equity emerged as a corrective mechanism, a gloss on the law designed to ameliorate the harshness of general rules when applied to the messy, non-linear realities of human existence. Now, for the contemporary legal scholars and the aspiring practitioners, the challenge lies not merely in memorizing the rules of equity, but in understanding those maxims, those foundational principles that guide the exercise of judicial discretion. This presentation serves as a substantive dissection of three critical maxims. He who comes into equity must come with clean hands. He who seeks equity must do equity, and equity looks to the intent rather than the form. So to understand this, we must look at their origin. The early chancellors were not lawyers but ecclesiastics, bishops and archbishops who acted as the keepers of the king's conscience. They adjudicated disputes not according to the stricture of the common law rules, but according to the canon law and the precepts of Christian morality. This theological origin explains why equity focused so heavily on the conscience of the individual. Now, where the common law asks, did the defendant break the contract? Equity asks, is it unconscienceable for the defendant to rely on his strict legal rights? This shift in perspective from legal entitlement to moral obligation is the thread that weaves through everything we will discuss today. Although the transition of equity from a system of conscience, famously derided by John Selden as varying with the length of the chancellor's foot, to a system of rigorous precedent was a centuries-long process culminating in the Judicial Act of 1873 to 1875. The intellectual distinction remains paramount. These maxims are not historical relics or petty proverbs. They are the operative algorithms of modern judicial discretion. They determine whether a multinational corporation can enforce a patent, whether a digital asset holder can reclaim the stolen cryptocurrency, and whether a cohabiting couple has created a trust over their shared home. Let's begin with the first maxim. Our first maxim is perhaps the most evocative expression of the court's refusal to be complicit in wrongdoing. He who comes into equity must come with clean hands. This maxim operates as a strict bar to relief. If a claimant seeks the discretionary remedies of specific performance, injunctions, or rescission, they must show that their own conduct in relation to the dispute has been honorable. Now, the rationale is twofold. First, it preserves the integrity of the court. For a judge to grant an injunction in favor of a swindler would debase the judicial currency. And secondly, it serves a deterrent function, discouraging parties from engaging in sharp practices. However, we must parse the definition of unclean hands carefully. As established in the seminal case of Daring the Earl of Winchelsea 1787, this is not a requirement of general moral rectitude. So the misconduct must have, and I quote, an immediate and necessary relation to the equity sued for. This is the nexus test. A claimant who has lived a life of a crime may still enforce a contract in equity provided their criminal history is irrelevant to the specific contract at hand. Conversely, a bishop who engages in fraud regarding the specific trust deed in dispute will be barred. So the application of this doctrine has undergone a seismic shift recently regarding illegality. For over 2 decades, the law in the Commonwealth was governed by the reliance principle from Tinsley v. Milligan. In that case, two women cohabited and purchased the house using joint funds, but registered it solely in Tinsley's name to fraudulently claim social security benefits. When the split happened, Tinsley tried to evict Milligan. The House of the Lords, however, held Milligan could claim her share, but only because she didn't need to rely on her fraud to prove her contribution. This reliance test was widely criticized for being formalistic. It meant success depended on procedural niceties rather than the substantive gravity of the misconduct. The legal landscape was revolutionized by the Supreme Court decision in Patel v. Mirza. Here, Mr. Patel gave Mr. Mirza £620,000 to bet on bank share prices using illegal inside information. The bet was never placed. However, Patel sued to recover his money. Under the old Tinsley test, Patel might have failed because he had to plead the illegal agreement. However, the Supreme Court overruled Tinsley, abandoning the reliance test for a flexible, policy-based approach. The court now considers three factors: the underlying purpose of the prohibition, what was the rule broken, relevant public policies, other policies like preventing unjust enrichment, and proportionality. Would denying the claim be a disproportionate punishment? This entire thing transforms the maxim from a rigid gatekeeper into a sophisticated balancing act. We also see this maxim in intellectual property. In cases like Terrasans v. Becton, Dickinson court grappled with inequitable conduct in patent prosecution. If a patentee withholds material prior art from the patent office, the unclean hands infect the entire property right, rendering the patent unenforceable. Furthermore, in the digital age, we see this used against copyright trolls, entities that seed their own content on pirate networks to entrap users. Courts apply the clean hands doctrine to deny them relief because they actively facilitated the infringement. Finally, consider the whistleblower's dilemma. An employee steals confidential documents to expose fraud. However, the employer seeks an injunction. The employee argues unclean hands, fraud. Court have held there is no confidence in inequity, but the employee must act responsibly. Indiscriminate leaking to the press rather than a regulator may be deemed unclean, bearing protection. While clean hands looks to the past, the maxim "he who seeks equity must do equity" looks to the future. It is the engine of conditional relief. It asserts that a claimant who asks for the discretionary aid of the court must be willing to act fairly towards the defendant. It prevents a litigant from cherry-picking the benefits of the legal system while evading its burdens. In the common law, a plaintiff who proves a breach is entitled to damages as of right. In equity, the remedy is a privilege, and that privilege comes with a price tag: the obligation to do justice. So one of the most technically intricate applications of this is the doctrine of election. This arises when a testator attempts to give property to beneficiary A, but in the same time instrument purports to give beneficiary A's own property to beneficiary B. So for an example, a testator leaves a legacy of £1 million to his son, but also leaves the son's vacation home to the daughter. Under strict common law, the son might claim the £1 million and keep his home. However, this defeats the testator's intention, and equity intervenes. The son seeks the equity of the legacy. To receive it, he might do equity by facilitating the gift to the daughter. He is put to an election: either to take under the will, convey the home, or take against the will, keep the home but compensate the daughter out of his legacy. He cannot approbate and reprobate at the same time. Now, in modern commercial litigation, the most frequent application is the undertaking in damages. When a plaintiff seeks an interlocutory injunction stopping a wrong before a full trial, there is a risk to the court where it might be wrong. The plaintiff might destroy a competitor's product launch and then lose the trial later. To mitigate this injustice, the court invokes the maxim. It says, "You seek equity, freezing the order. You must do equity, promise to pay for the defendant's losses if it turns out you were wrong." Without this undertaking, the injunction would be a tyrannical weapon. Historically, this maxim also underpinned the consolidation of mortgages. If a borrower had two loans, one secured by a valuable property and one by a property that lost value, equity permitted the lender to consolidate them, forcing the borrower to redeem both or neither. The logic was, you seek the equitable right to redeem your property, so you must do equity by paying all your debts to this lender. Finally, this maxim manifests as promissory estoppel. In the high trust case, Lord Denning applied this principle. A landlord promised to reduce rent during World War II. After the war, he sought back rent. The court held that because he made a representation that the tenant relied on, it would be inequitable to do renege. He had to do equity by honoring his promise. Even in international law itself, judges at the ICJ have applied this concept, noting that a state cannot complain of a treaty breach if it has breached the same provisions itself. Our third maxim is equity looks to the intent rather than the form. The common law was historically obsessed with form. The presence of a wax seal often determined the validity of a contract. Equity arose to combat this. This maxim asserts that the court will identify the substance of a transaction and give effect to the parties' true intentions, even if technical formalities have been botched. So the most prevalent application is in trust. For a trust to be valid, there must be certainty of intention, but the word trust need not be spoken. Consider Paul V. Constance. Mr. Constance lived with his partner, Miss Paul. He opened a bank account in his sole name. That was the form. But he repeatedly told her, the money is as much as yours as it's mine. And they deposited joint winnings there. When he died without a will, the court applied the maxim. Despite the lack of a formal deed, his words evidenced as an intent to create a trust. The court looked through the form of the sole account to the intent of the relationship. This is a pivotal for social justice, protecting those who do not hire lawyers to draft deeds. We also see this in the equity of redemption. The history of a mortgage is a battleground between form and intention itself. Historically, a mortgage deed said, borrower transfers land to lender. If borrower pays by January 1st, he gets it back. If he paid on the January 2nd, the common law said he lost the land. Equity intervened, saying the intent was a loan with security, not a sale. This created the right to pay late and led to the rule against clause on the equity of redemption, striking down clauses that restricted the borrower's right to get their property back. So once a mortgage, always a mortgage. In contract law, we use rectification. If a written contract contains a typo, $100 instead of $1,000, equity allows party to prove their true consensus and physically amend the document. Now in Chartbrook v. Persimmons's home, the House of Lords used the matrix of fact to interpret a contract in line with commercial common sense, ignoring the literal meaning that produced absurdity. Now similarly with penalties versus liquidated damages, the court looks to intent. A contract might label as a sum of liquidated damages, but if the intent is to terrorize the other party in performance, equity ignores the label and strikes it down as a penalty. The most critical modern application of these maxims lies in digital assets, blockchain and DeFi. This domain presents a unique challenge. The ideology of code is law. Crypto purists argue that if the blockchain code permits a transaction, even a hack, it is valid. This is the ultimate triumph of form over intent. Equity fundamentally rejects this. In cases like AA versus Persons Unknown and Tulip Trading, the High Court confirmed crypto assets are property and subject to equitable principles as well. Now, regarding intent versus form, even if the blockchain ledger, the form itself, says a hacker owns the Bitcoin, equity looks to the intent. The original owner did not intend to give the assets. Therefore, the hacker itself holds the assets on a constructive trust for the victim. Regarding clean hands, if a user loses private keys due to their own negligence or while trying to evade taxes, they may struggle to get discretionary relief due to the clean hands doctrine. We also face the issue of rectification in smart contracts. If a smart contract contains a bug that locks away millions, the form says the money is lost. The intention was clearly to have accessible funds. So while the court cannot rewrite the immutable blockchain, it can order the parties to execute a new transaction to reverse the error. We are entering an era of equitable code where the chancellor's foot must navigate the immutable ledger. To conclude, the maxims of equity are the genetic code of the chancery jurisdiction. They ensure the law remains a servant of justice rather than a master of technicality. Clean hand ensures the moral standing of the claimant, protecting the court's integrity. Seek/due equity ensures the fairness of the outcome, mandating reciprocity. Intent versus form ensures the reality of the transaction prevails over the paperwork. For the student and practitioner, these are non-archaic phrases. From the family courts in Paul v. Constance to the Supreme Court in Patel v. Mirza to the High Court freezing Bitcoin, the maxims are alive. They represent the law's acknowledgement of its limits. Rules cannot foresee every eventuality. The maxims provide the structured discretion necessary to bridge the gap between the rigidity of law and the fluidity of life. The chancellor's foot may have been a variable measure, but the chancellor's conscience remains the ultimate safeguard of justice.